Pare ko nandun si Soto.
Dapat na lang lagay na lang na lawyer si Soto. Ulitin natin. Ayan na. Ay. Nawala. Mahina internet eh. Inayos ko pa. Good evening, Rosemary. Reginan. Eduardo Obisos. At from United Kingdom, makauwi na pa si tatay. Malamang po. Dali lang, dali lang. Wala. Dali lang. Ulitin ko naman ulit. Ulitin ko naman. Ito po ay bunga ng mahina internet ko. Pasensya na po sa inyo.
So, Madam President, Your Honours, we were discussing Command Circular number 16 of 2016 and the issuance of PNP Investigative Directive number 12 of 2016, which set out additional policies and guidelines in the conduct of double barrel. This directive instructed investigative units on how to perform their responsibilities in the case of armed confrontation during the implementation of Operation Double Barrel. The document also included an exhortation to monitor human rights violations perpetrated by PNP operating units. The term neutralization itself is, of course, not defined anywhere in any of these documents as meaning to kill, a point the prosecution itself conceded at that moment in time when it was seeking the opening of an investigation. And I refer, Your Honours, to ICC 01/21, document number 7. So the prosecution, throughout its pre-confirmation brief, invites this chamber to find, by inference, that neutralization means murder, and even carves it in stone.
Dito po, ina-argumento, pinipresenta po ni Attorney Kaufman yung CMC or circular na may directive na neutralization. So, ini-invite din yung mga judges sa mga prosecution to find in that document that was issued in 2016 na kung may sinasabi ba doon, ang ibig mong sabihin ng neutralization ay papatay ng tao. So, china-challenge niya. So, walang makikita. In other words, to make it short, ang pinipresenta ni Attorney Kaufman ni ebidensya ay yung pinalabas ni Bato na circular na nag-utos ng neutralization, pero walang sinasabi doon ng neutralization na ibig sabihin papatay ng tao. To the contrary, o sa kabila ng lahat, ang nakalagay sa memorandum circular, inuutosan ng mga pulis na mag-observe ng constitutional rights ng mga akusado. Ang inutos lang po doon mag-aresto. Ngayon, walang inutos doon kundi na pumatay, kundi mag-aresto para ma-neutralize ang drug addiction sa bansa natin.
known as its formal statement of the common plan. But we, the defense, can show that the term neutralization can only mean the use of self-defense where officers' lives are endangered. For this, the text of the circular must be read in the context of the governing framework and other PNP directives. It is our submission that across the political, legislative, judicial, and law enforcement contexts, the consistent articulation has always been that neutralization denotes lawful restraint. At the executive and operational level, the Chief of the Philippine National Police, Ronald de la Rosa, Bato, publicly clarified in 2017 that neutralization means arrest. Furthermore, in an official transcript dated 28 October 2024, the former Chief of Police, De La Rosa, testifying for the Committee on Accountability of Public Offices and Investigations, testified that the term neutralization was anchored in the PNP Operational Procedures Manual, where it is specifically and strictly defined. Let us just have a look at what he said. And for your ease of reference, we will also display the said passage in the PNP Operational Procedural Manual to which De La Rosa referred, which incidentally was published in 2021. Neutralization, and I quote, "A police intervention in strict accord with the use of force continuum and/or principle of proportionality on the use of force purposely to contain or stop the unlawful aggression of the offender. This may include an arrest, capture, surrender, or other acts to subdue the suspect." It strikes us as rather mind-boggling that the prosecution should have failed to appreciate the significance of this. It was aware of De La Rosa's speech because they disclosed it to us. But the prosecution's investigators clearly never bothered to read the procedural manual to which De La Rosa was referring. In fact, we know that they didn't, because it's not on their list of evidence. Within the judicial sphere, when the terminology was examined before the Supreme Court of the Philippines, in petitions challenging aspects of the anti-drug campaign, the government defended the circulars on the basis that they did not confer a license to kill. The Supreme Court
Pero sinabi dito sa memorandum circular na pinalabas ni Bato de la Rosa, wala po siyang utos diyan na papatay ng tao. Ang inutos niya mag-aresto, lahat klase, so wala siyang inutos na magpatay ng tao.
of the Philippines, however, to date, has declined to issue any ruling declaring the campaign unconstitutional, has declined to invalidate circulars, and has declined to rule to date that neutralize or neutralization means to kill. The Supreme Court's treatment of the issue is particularly instructive. The court observed...
So, dito, sinight din ni Kaufman na depensa. So, in-invoke ni Kaufman ang decision ng Supreme Court ng Pilipinas na nagsasabi na legal ang tukhang, legal ang double barrel, at walang sinasabi doon na pumatay na citizen.
That the wording was neither novel nor introduced during the Duterte administration. It had already appeared, for example, in the 2014 revised PNP manual on anti-illegal drugs operations and investigation. In other words, the term formed part of the existing police vocabulary. The court further clarified that the mere inclusion of the term in a circular does not render that instrument unconstitutional, especially where the circular expressly mandates compliance with internationally accepted legal principles, public policy, and the full observance of human rights, as we showed you earlier. No circular has been invalidated on this basis.
Klaro sinasabi ni Kaufman, yung Supreme Court decision na hindi na dineklara na valid ang tukhang, valid din ang lahat ng mga issuances, ay in fact, to the contrary, pinupuri pa ng Supreme Court. So, ang mga nag-petition dun sa Supreme Court laban sa tukhang ay yung mga makakaliwa. Pero natatalo sila sa Supreme Court ng Pilipinas. So, ginamit ngayon ni Kaufman itong decision ng Supreme Court dito sa DEFENSA na kung ang Supreme Court ng Pilipinas ay nagsasabi na hindi illegal ang tukhang, ano pa kaya ang sasabihin ng ICC judges?
Nor has it ever been established at the highest level of domestic judiciary that to neutralize means to kill.
So walang sinabi sa
The judicial record does not
ay to kill.
sustain such an equation. In each institutional setting, therefore, the term has been situated within ordinary policing powers and constrained by the lawful use of force framework. The testimonies of those operating within that framework,
The highest domestic court,
the prosecution's
that it is
witnesses,
legal. So
no
what do
less,
we do?
are aligned with this documentary record. For example, witnesses P1158 and P1170 explained that neutralize means to arrest or to incarcerate through legal means. It did not mean to kill. Witnesses P1050 and P1174 confirmed that lethal force arose only where a suspect's resistance placed an officer's life at risk, reflecting the ordinary doctrine of self-defense and consistent with Mr. Duterte's repeated public declarations that force was justified only in such circumstances. P1214 further indicates that operational decisions were made by officers on the ground within established protocols. So,
Maître, je suis désolée de vous en...
I'm sorry to interrupt, counsel, but once again, you need to be specific and provide the document reference number. You must specify the document number, the reference number for us.
if I may, Madam President,
Merci beaucoup,
of course,
Thank you very much.
an understanding with the learned chambers legal officers that we would be able to provide references after the hearing. But of course, the document that I was referring to is PHL OTP 00090518 R01. So, Madam President, Your Honours, taken together, the manual, the public clarifications by police leadership, the state's position before the highest court in the Philippines, and even the prosecution's own corroborative witness testimony, all of this material demonstrates a coherent and consistent understanding that neutralization was articulated as lawful incapacitation through arrest and related measures, not as a policy of killing. And if the prosecution's case for the common plan in counts 2 and 3 is based on Command Circular number 16 of 2016, we might as well pack up and go home because Mr. Duterte is simply not guilty. However, for the sake of completeness, I continue. The fifth indicator of a common criminal plan.
Ibig sabihin, sa kaninang discussion ni Kaufman, he still insisted, nag-cite siya ng iba pang dokumento na nagsasabi at kasama sa dokumento na sinasite niya ay yung decision po ng Supreme Court ng Pilipinas na mismo nagsasabi na ang oplantukhang at sa mga HBT na yan ay legal. At ang salitang neutralization ay hindi po nagtutukoy sa papatay ng tao, kundi legal incapacitation ng mga akusado, ng mga gumagamit ng droga. Ibig sabihin, legal incapacitation, it means arrest, it means incarceration, and whatever other forms. But it did not include the act of killing. Ganon po ang sinasabi ni Attorney Kaufman. Very good. Tapos, let us proceed. Ibig sabihin po, ginamit pa ni Attorney Kaufman na depensa yung Supreme Court na decision. So, pwede rin natin sabihin na nagkamali pala mga kalaban ni Digong na noon ay nagsampa ng kaso sa Supreme Court laban kay Digong. At kung gano'n at natalo sila sa Philippine Supreme Court, ginamit ngayon ni Attorney Kaufman yung decision ng Supreme Court ng Pilipinas. Na ang punto niya ay kung ang mismo ang pinakamataas na korte sa Pilipinas ay nagsasabi na hindi yan illegal, then what can we now say? Hinahamon niya ngayon ang mga prosecution at sinusumiti niya ito sa isipan ng tatlong judge sa pretrial chamber. At nakita ko attentive, very attentive ang mga prosecutor, ang mga judges makinig.
As alleged by the prosecution in paragraph 28 of the pre-confirmation brief, appears to be the concerted broadcasting of inflammatory speech. Here the prosecution once again selectively cites excerpts from 2016 media interviews with Ronald de la Rosa, Bato, and Vitaliano Aguirre, which suit its purpose and case theory, while totally ignoring the more unequivocal comments in those interviews which destroy its case. Regarding the interview with De La Rosa, mentioned in paragraph 28, after supposedly inciting a crowd of drug addicts to cause criminal damage to the properties of their narcotics suppliers, the newly elected chief of police states, "It's either you will die from police gunfire," and he adds, "if you resist." That's PHL OTP 0000849, page 2. Likewise, with the comments in an Al Jazeera interview, PHL OTP 0009 0340, comments attributed to Aguirre, from which the prosecution imputes criminality to Rodrigo Duterte by citing Aguirre's comment that the administration's policy was to stop crime and kill drug lords. Such throwaway comments reflect on Aguirre alone. And God forbid, we're not alleging that Aguirre did anything wrong. Especially when, in the very same Al Jazeera interview, Aguirre states, not once, but twice, that the policy of Duterte himself was for the police to use lethal force only in self-defense. We can display that on the screen, and the part that I want to read is highlighted. And President Duterte was very clear on this matter, he said, Aguirre, that there will be no killing of unarmed offenders, meaning to say that you use force only when your life is in danger. Later on, in the very same interview, Aguirre would repeat the same theme which exculpates Mr. Duterte, PHL OTP 00090340 at page 4. And I read out the relevant passage which is highlighted once again. They are supposed to arrest them, but when they fight back, then the president has instructed them that they must first protect themselves. So much for Mr. Jeremy's elastic mouth theory. Even he thought that Duterte's speech was bifurcated. And even if he did think so, his so-called perpetrators did not. So why does the prosecution cite the excerpts which support its case so selectively? Well, I'm not going to impute any malfeasance, but I can hazard a wild guess. I would suggest that the people reviewing the prosecution's massive databases for suitable evidence are performing keyword searches. Most likely, some of the most utilized operands were the words kill and perhaps sometimes neutralization or neutralize. Once the member of the prosecutor's staff has his hit, he excises the excerpt, rejoices that he can slot it into the predetermined case theory, and does not bother to read the rest of the item of the evidence, where the exonerating evidence is unequivocal. Turning to the sixth.
Ibig sabihin, kinlaro ni Kaufman na yung ginagawa ng mga prosecutor ay they only read the portions of evidence that is incriminating against Duterte. And they are not reading, they did not bother to read all the statements in the same document that are exculpating to Duterte.
Indicator of the supposed criminal plan, as set out in paragraph 29 of the pre-confirmation brief. None of the speeches imputed to the former president, nor the use of what the prosecution calls dehumanizing language, dehumanizing language by the alleged co-perpetrators suggests criminality. I would suggest that it is within the bounds of acceptable, albeit extreme political discourse, to refer to drug users in such a way as beasts, animals, or to the barangays as being plagued by the drug menace. Well, the last one is true. you can hardly expect populist politicians and law enforcement officers to refer to drug pushers and criminals as upstanding pillars of the local community. I really do feel that the prosecution is at a loss if this is its circumstantial evidence for proving the existence of a common criminal plan. The same goes for the seventh supposed
Ang
indicator.
ginagawa nila, circumstantial evidence lang pala gagamitin nila para ma-prove nilang tinatawag ng mga prosecutor na common plan. Common plan na kailangan, pinent out ni Kaufman, for one common plan to become a crime, there must be a common agreement mutually agreed upon the members of the plan. So ito, wala sila may pinakitang ebidensya na nag-agree si Bato, si Albayalde, si Duterte, si Director Giran, si Isidro Lapina, si Vitaliano Aguirre, si Oscar Albayalde, at saka yung namatay na PNP chief na si Cascolan.
Of criminality, which is based on the names created for the two police operations, Double Barrel and Tokhang, along with their supposed evocation of firearms metaphors. While the source for this particular gem, witness P1207, a self-confessed murderous villain, might have guns perpetually on his mind and insert their imagery into his daily speech, it does not mean that those who formulated the anti-drugs policy were acting under a similar caprice when they devised the nomenclature for these two particular police operations. And of course, there were other police operations with completely different imagery, such as the one-time, big-time operation referred to by a few prosecution witnesses, and the riding in tandem operation. The mind can only boggle as to what type of nefarious imagery the prosecution believes that last title evokes. None of the indicators I have mentioned up until now have shown in any way a mutual meeting of minds between alleged co-perpetrators, evincing a communality of purpose or an agreement.
Sinasabi ni Kaufman, until today, na nagsasalita siya, wala pang naipresenta na ebidensya ang prosecution na magpapatunay na nagkasundo-sundo nga, na nag-agree nga sila ni Bato, si Albayalde, si Danao, si Dante Giran, si Lapina, si Vitaliano Aguirre, na magkaroon ng common plan na pumatay.
Agreement to act in an illegal fashion. Of course, the prosecution has shown us pictures of the alleged co-perpetrators uttering comments similar to those issuing from Rodrigo Duterte. But this does not indicate a meeting of minds, as I will...
Sabi niya, meeting of minds. Sa mga estudyante sa civil code, sa mga CPA students na nagkapag-aral ng civil code, ay meeting of the minds. Pag sinabi meeting of the minds, nagkasundo ang dalawang partido o maraming partido na ang kanilang mga isipan nagkakasundo, meeting of the minds, para magkaroon ng common plan. Ngayon, Kaufman is repeating all over and over again that the prosecution has never presented any evidence to prove what the prosecution called as common plan to kill.
Elaborate shortly. The eighth factor, purportedly evincing a plan of agreed criminality, is set out.
Oh, naputol na naman. Anong klase ito? Pinuputol na pa sa si Kaufman magsalita. sinasabotahe ni Bongbong Marcos ang depensa ni Duterte. Oh,
as would be required for a common criminal plan or a common plan. Concerning and coming to the 9th category of circumstantial proof for a common criminal plan, the prosecution relies on what it believes to be the Duterte's administration's unabashed publication of statistics recording the number of deaths occasioned in the context of the so-called war on drugs. But let us just look at how and where the statistics relied upon were being published.
tingnan natin
In
statistics.
2 government reports, the first of which being the Duterte administration's year-end report for 2017, totaling 63 pages, covering every sector of government and the economy, and of which just 2 pages are devoted to policing activities. We can give you the document ID number shortly. It's on the screen. While the deaths of 3,967 drug personalities mentioned are indeed recorded, as Ms. Robin Croft
So,
helpfully pointed out
118,000
in
arrested
her
person.
presentation, and are not insubstantial,
So,
these
arrested
deaths
lang hindi
comprise a
patay.
fraction of the 118,287 total arrests for drug-related activities, especially when the government is conducting special operations in a concerted drive to curb the narcotics problem. Such statistics are certainly not indicative of a wholesale policy of murder designed to supplant the process of law. If they were, then certain Latin American state parties would have regularly equaled or exceeded the Philippines in the number of law enforcement killings per capita of the population. What is quite egregious, however, regarding the prosecution's reliance on the 2017 Key Achievement Report is the way in which it glosses over, or rather ignores, those pages which do not suit its case theory. Take, for example, pages 28 of the document, which highlights the fact that 1,900 drug-related investigations had been carried out against law enforcement officers in the preceding year, with 375 police officers being dismissed, including the 2 policemen
I want
involved.
to highlight this. Nag-report pa si Duterte na 800 plus na pulis ang na-dismiss na nagkasala sa mga police operations sa anti-drug.
In the murder of Carl Arnaiz,
So, ang nag-murder kay Carl Arnaiz ay dinismiss from the service.
who were later convicted and sentenced to life imprisonment.
So yan hindi nag-consente si Duterte yung mga pumatay, sinintensyahan.
These policemen were affiliated with the Caloocan City Police Station, and where, so the report mentions, 1,000 personnel belonging to that station was sent for retraining.
Okay. Nagre-retrain pa nagre-retrain pa si Duterte. Yun, parang parang namumugto ang mata ni Prosecutor Minjayan niyang, Di sila ka makapaniwala sa depensa.
To conclude, this document, far from being evidence of a conspiracy hatched between co-perpetrators, is in fact a testament to the Duterte administration's respect for the rule of law and written proof of its intolerance for rotten apple police officers. As for the second official publication, which is supposed to substantiate the criminal plan. We turn to the 2016 annual report issued by the Philippine National Police. The statistics are quoted with all respect in a misleading fashion. The tables used by De La Rosa, and particularly the pie chart, show a remarkably low incidence of deaths in comparison to arrests and voluntary surrenders. Obviously, the misleading aspect of that is the prosecution's representation of the statistics, not De La Rosa's. So, coming to the 10th and final source of circumstantial evidence, supposedly.
Ito po may mga circumstantial evidence na binibira ng ano naman to? Okay.
Criminal direction to target drug users for murder, criminals for murder, when he states that on occasion
Talagang pinutol-putol
he would
nila.
perform so-called clean arrests. Prosecution's witness, P3. He's not clear when he's actually following their supposed criminal theory or when he's is. What are clean arrests? These are arrests subsequent to which the apprehended criminal would be handed over for a judicial process. And so with that, I believe, I have exhausted the first limb of the objective requirement for indirect co-perpetration and have shown conclusively that there was no mutually agreed common criminal plan. Madam President, there are 10 minutes to go. I will start with the concept of essential contribution, which is indeed the second limb that I want to talk about with respect to this mode of liability, which requires the prosecution to show objectively that Mr. Duterte himself made an essential contribution to the furtherance of this scheme of criminality, and what is more, that subjectively he was aware that he was making such a contribution. This is what us Latin-speaking lawyers, would call the sine qua non test. Or to put it another way, did these 49 murders, which the prosecution has identified, occur specifically because of Rodrigo Duterte's involvement? Or, to make the logic a whole lot simpler, would Rodrigo Duterte's withdrawal from this criminal scheme to target suspected criminals, as alleged by the prosecution, have led to the avoidance of these 78 deaths? Let us see where this test is set out in the Ali Koshaib trial judgment. Paragraph 796. And I'm going to quote the essential part for the purpose of the essential contribution. The accused must make an essential contribution without which the commission of the offence would not be possible. To hold an accused liable as a co-perpetrator under Article 25(3)(a) of the statute, it has to be established inter alia that he or she had control over the crime.
Okay, explain ko lang. In-express at in-stress ni Kaufman na kung meron ko pinu-point out na ang mga bagay ay kailangan ipatunayan ninyo na iyan ay nagtuturo na si Digong ay nag-utos talaga na pumatay. At kailangan obserbahan nyo rin, halimbawa, kung wala yan, mangyari pa ba papatay o hindi? So in other words, kulang sila sa ebidensya at sa kanilang ginagamit sa circumstantial evidence.
Virtue of his or her essential contribution to it and the resulting power to frustrate its commission. Well, here, I would like to show you the statistics pertaining to the rate of killings since the former president has left power and the responsibility.
Ito naman, ipakita ni Kaufman na mas marami pang namatay sa panahon ni BBM kaysa panahon ni Duterte. O ito, pakinggan natin.
For law and order has passed into the hands of President Ferdinand Marcos Jr. I rely on a report published by academics at the Third World Studies Center in the University of the Philippines in the context of what is called the Dahas Project. And trust me, the authors of this report, comprising weekly statistics on the first year of the Marcos administration from 2022 to 2023, are no great friends of the former president, Mr. Duterte. This report was even cited, I remember, in a Rappler article, but it's to be found on our list of evidence at PHL D36 0006 0001, pages 006 to 0010. The report for the first year of the Marcos administration showed that out of 342 killings, 160 were at the hands of state agents. And the figures and the statistics just kept on rising. With the second year of the Marcos administration, 2023 to 2024, showing an increase in deaths at the hands of vigilantes, albeit a decrease in deaths at the hands of law enforcement officers, from 46.8% to 34%. Hardly a statistic to be proud of. So, with all the prosecutions, fancy bar charts, I'm pretty sure that if they were to recreate them for the period of 2 years after Duterte left power, they wouldn't have room left on their computer screen. The numbers would be so sky high. The conclusion is that there is no reason to believe that Duterte's disappearance from the political scene would have frustrated the ongoing incidents of murder at the hands of state agents or vigilantes. Clearly, I'm forced to ask myself whether anyone on the other side of this room has thought of investigating the Marcos regime and the
Tinira kayo ni Kaufman. Yung mga patay sa panahon ni Marcos, hindi niya inimbestiga.
related phenomenon and holding someone accountable. Why are my colleagues sitting to their right, the victims' representatives, not clamoring for accountability for those deaths? Or is it of no consequence now that Mr. Duterte is sitting in the ICC detention center? I've reached a natural break, Madam President, in my
So,
submission.
ngayon, pinapoint out ni Attorney Kaufman, habang nasa loob ng kulungan si Duterte, ang daming namamatay sa Pilipinas. So, yan po ang
With your permission,
ang second. Mamaya, after 5 minutes, ilabas natin po ang third. Pusoy na sila. Okay, maraming salamat po. Babalik kayo after 5 minutes. Balik after 5 minutes. Pero, bago po, paki-like po para ma-notify kayo pag live ko na. Kanina, medyo mahina lang yung signal ko. Medyo, delay. So, anyway, after this, bibira na natin ang third and final presentation ni Attorney